All right, we are live, everyone. Hello. We have some folks just in the waiting room coming in, so we're just going to wait a few minutes as folks enter. But it's great to see some familiar faces and familiar names. Hello, Kelly. Oh, Claudia, of course, Claudia Jakubiak is always.
Hey, Claudia.
She never misses. She never misses the Careers in Cannabis event. Hey, Naomi, good to see you. Jamie, Kelly, hello. Looks like quite a few folks are here. Awesome. We got quite a few folks joining. So we're going to go ahead and get started since we should be kicked off just a few minutes after 4 here. So my name is Sloan. I'm the founder and CEO of Engine Sciences, which is the tech platform behind careersincannabis.com, which is our employer brand and job search site for the cannabis industry. And I'm joined here by my colleague, Melissa, who runs our community and is the amazing person behind putting on all these events. And she's going to introduce our panelists, Stephanie and Charlie, who are going to talk about wage and hour law in the cannabis industry. Melissa, take it away.
Awesome. Hi, everyone. Thank you so much for joining today. It's great to see some familiar faces and some new ones. My name is Melissa O'Brien. I'm the community manager here at Engine Sciences and Careers in Cannabis. We're all excited to have this important discussion on wage and hour laws with Stephanie and Charlie from Shook, Hardy & Bacon. Throughout the webinar, if you have questions, feel free to drop them in the chat or write them down. You can save them for the end. We'll have a Q&A. So I'll go ahead and pass it along to Charlie and Stephanie and get started.
Thank you. So we are presenting today on wage and hour in cannabis. Know the basics. Just some brief intros here. My name is Charlie Rosebrough. I am an associate here at this law firm. This is Shook, Hardy & Bacon. I'm in our business litigation group. I do a lot of employment type work. I do everything from sort of single plaintiff discrimination cases all the way up to your big class actions for missing time, off the clock work, misclassification, things of that nature.
And hi, everybody. Excited to be here today. My name is Stephanie McGraw. I'm a partner at Shook, Hardy & Bacon in the Houston office of our firm. I am in the product liability group as well as the cannabis group. And I have a diverse practice that runs from product liability and food and beverage issues to class action and complex and multi-district litigation. So really big cases with thousands and thousands of plaintiffs. And in the last 5 years or so, I've been doing a lot more business lit in the cannabis industry. So we are excited to be here today to talk with all of you about wage and hour law and some ancillary issues that come up through that. And with that, Charlie, why don't you take it away?
All right. Very quickly before we get started, we do have a disclaimer that as lawyers and our ethical duty requires of us, we like to post before we talk about any aspect of the cannabis industry. I'll leave it up for just a second if you want to breeze it over before we get started. All right. So on a broad scale, the big question is sort of what is wage and hour law? Wage and hour law is an umbrella term. There are quite a few things that fall into wage and hour, but perhaps the easiest sort of breakdown to think about it is from federal down to the state level, down to the local level. And for all employers, you are going to have to deal with these three buckets, the federal, the state, and the local level. But the federal and the state sort of see the most litigation and are the most important to deal with. So for your federal law, your two big actors here are going to be FLSA and FMLA. The FLSA has sort of the wage requirements, the overtime requirements, exemptions, things like that. FMLA has exactly what it says, these leave portions. I throw Title VII and ADA in there just to mention them. They don't get as much play in the wage and hour sphere. These are really discrimination statutes, but every now and then you may have some Title VII issues creep into payment problems. On top of the federal law, you'll have state law issues, and frequently, if you are being sued for something, you will have parallel track state cases and federal cases brought together in the same suit. For state law, I think every state in the country has sort of their partner statutes to the FLSA and the FMLA, but we're going to focus on California today for a couple reasons. One is it's a big cannabis sphere, but also because California frequently leads the country in employment protections. And so you will see sort of the most stringent and the most active plaintiffs bar in California first, and that usually trickles down to your Midwest and then East Coast states. All right, I'm going to talk about the federal highlights just for a second. So for FMLA, some big things to know. First, it's good to know, are you covered? So that's going to be, is the FMLA applying to my business? The big cutting point here is 50 or more employees. And that can sound pretty large at first, but you'd be surprised how quickly you can hit 50 employees. And it can be employees that are employed for different periods of time. So sometimes if you're cycling employees, you need to check with an attorney, make sure that those employees are or are not being counted properly towards that total. The other aspect is the employee has to have been with the company for a year to be entitled to that FMLA leave. If you are a covered employee and you are eligible for this leave, you are entitled to 12 weeks of unpaid leave, and it has to be for a serious medical condition. For the FLSA, and this slide could be about 30 times as long for the things that the FLSA covers, but the big hitters are the minimum wage. You have $7.25 an hour is the current federal minimum wage. And the minimum wage works its way into litigation a lot of times when you have off the clock work that you believed you were paying for, turns out maybe you're not. And then if there are a few hours put into that, let's say someone has 5 extra hours that they worked in a week, they weren't paid for it, they bring a lawsuit and you were paying minimum wage. At that point, you're paying below the minimum wage because you are actually paying maybe $7 an hour for the work. If you calculate it out over the actual hours worked, those can be violations. Second is the overtime requirement. The overtime requirement, time and time again, is a subject of suit for the misclassifications, things like that. And then, of course, you have the big exemptions. The big three are administrative, executive, and professional exemptions. I threw the farm workers exemption on here for specifically the cannabis sphere. If anyone's curious about it, we can maybe handle it in questions, but there is a sort of minute exception for certain employees that are doing farm work or agricultural work, I think is maybe how the federal statute describes it. It has its own sort of parameters, sort of 500 working hours in its farming sphere. We can talk about that, but that is a potential exception to the overtime requirements in FLSA. All right, I'm going to turn it over to Steph.
Yeah, so on the screen right here, we have a few kind of the big highlights of California. Obviously, California is a huge player in the cannabis industry, and they have been on the cutting edge, not only for cannabis, but also, as Charlie mentioned, for labor and employment law and regulations that are, very progressive and very employee and worker friendly. I don't want to read the slides to you. Everyone can see what's up there. I think what's important to note is that, as California goes, so does a lot of the country and a lot of the other jurisdictions that are now legalizing cannabis in any number of ways. And so, another state that has strikingly similar regulations is Massachusetts. Massachusetts is really kind of getting out in front and being a progressive leader for employee rights and certain types of time off for even things, like a minimal amount of time off. I think you get 24 hours to be able to attend things like your kids' games, and that accrues throughout a year. So there's a lot of kind of state and not just federal, but also state and state specific things that you really do need to pay attention to make sure that you are complying with everything that you need to comply with as a business. So here on the screen, we have a few that touch on, the minimum wage requirements for California. Minimum wage legislation and policy is always something that you want to pay attention to because it is frequently changing. And obviously there's been a lot of momentum in this country to increase minimum wage. And then of course, Charlie, if you want to go to the next slide. One of the things that I want to highlight is the last bullet point, the employees working outside being provided with a recovery period or a cool down period. This is something that I think, especially this summer, given the heat waves that the Pacific Northwest saw, really became a hot button issue. So much so that the Biden administration is directing OSHA to essentially come up with a federal companion to this, and to have OSHA, which is the federal administrative organization that oversees workers in the workplace, to develop standards for this type of cool down period, this type of rest period. And I think that as the climate continues to change and there are different challenges with having workers be outside for long periods of time, this will be an important area where we will continue to see evolution. I think one of the reasons why we are here, today to talk with the cannabis industry is that as the industry continues to mature, it becomes ripe and vulnerable for litigation. For example, in the last year, from 2019 to 2020, there were 100 class action lawsuits targeting the cannabis industry. And plaintiffs are starting to pay attention as an industry starts to grow and to become more profitable, it will become a target. And I think you all in your position as human resource professionals really are uniquely situated to not only do what's right for your company and what's right for your workers, but really protect the industry and protect your companies from class action litigation or even individual one-off litigations. So I don't know if there are any questions or if there's anything in particular that anyone wants to hear a little bit more about.
Right now, we don't have any questions, but folks are free to enter questions into the chat. And we encourage people to do so. You can enter them into the chat or to the Q&A function. But as of right now, there's no questions so far. So I keep on trucking. And then again, folks, we encourage you all to ask questions. Stephanie and Charlie normally charge by the hour. So this is nice to be able to get your questions answered.
Well, without a question, I've got maybe my sort of two big top hints if you're starting a business or if you are really starting to get a big foothold and you're trying to dodge some of these bigger class actions. The time and again, the most important class that we'll see for FLSA is a misclassification class. So it's very, very common to either classify maybe your managers, if you have brick and mortars, maybe distribution centers, and they're smaller entities, they've got maybe a couple hourly workers and then one manager who's overseeing everyone. Frequently, a business will like to classify that manager under the executive exemption and will not pay overtime for that position. I'm thinking right now about a gas station company that I'm representing that got hit with a suit for this, where they were classifying their managers of each gas station chain under that exemption. The suit would be that you need to be spending a certain portion of your time every single day in managerial type roles. If you're not managing, but maybe you're the only person in the building that day and you're running the cash register as people are coming in, you might not meet that exception. And then if you're not being paid overtime for the extra hours worked, that's going to be hit with maybe some civil penalties, misclassification. And then usually you're going to wind up paying attorney's fees for the plaintiffs as well. So I would say that anytime you are deciding on that classification for managers, for professional employees, for high paid workers, to take a really strong look at that and probably seek some legal advice, because they can become pretty large suits, especially if you're having large classifications across a lot of different employees.
Yeah, that's great. And just to kind of elaborate on that point, in California, there's up to a $25,000 penalty for each misclassified worker. So you really do want to, this is something that, you know, is a frequent target in employment class action litigation, and it is something that, you know, you really do want to pay attention to.
California especially can be a dangerous area for litigation because of the Private Attorney General's Act, or PAGA, as people call it. As you can probably guess, the agencies in the state of California have a difficult time keeping up with the population sizes. And so the legislature decided to pass a statute that allows plaintiffs' attorneys to sort of act as private attorney generals. And they can bring cases on behalf of the state in a private capacity, and 75% of the recovery will go to the state of California and 25% goes to the plaintiff. That has really opened the door for some pretty serious litigation and allows enterprising plaintiffs bars to sue for any small violation of the labor code. So you really, if you're in California, if that's a jurisdiction you're in, you want to be extra cautious. There are lots and lots of small labor issues to deal with in California. You have to provide suitable seating. Seen a lot of suitable seating cases where if you don't have stools and you don't have chairs for your workers, that's going to be a violation. Rest break issues, you really need to be diligent about giving those 15-minute breaks, about giving lunch breaks and making sure that your employees are taking those. And then off the clock work, you need to be very careful with off the clock work. We're not in, you know, the 70s anymore. There's not a punch card when you come into work that you kind of smash next to the door. A lot of times people either log into computers or are sort of reporting it just by word of mouth. But if you're not recording all the time properly, especially in a remote setting, if you're not recording all the time properly, it's very easy to miss hours that have worked. And you have to pay for all of those hours. So what you don't want to have happen is 6 months down the road, you realize you haven't paid for 40 hours of your employee's time, and maybe across the whole board. And then in California with PAGA, that becomes a very difficult suit.
Right, and I think that's a really important point, Charlie, is that, you know, an hour here, an hour there doesn't sound like that much, but then all of a sudden, when you have attorneys who are going out and actively collecting these claims and you know, talking to, especially if you're a larger company, I mean, you're talking about hundreds of hours, and that can really add up. I know in some states, for example, like Massachusetts, I think in Massachusetts, if people don't take breaks, then you have to actually pay them for that time. So you really do want to be vigilant about, you know, enforcing breaks for your hourly employees. It looks like we're getting some questions. So Megan, hi Megan, or Sloan, do you want to read those? How would you like to?
I'll read it just so everyone sees it. But Megan Van Fossen, thanks for asking, Megan. For individuals who have transitionary roles, like the manager you were talking about, do you see people using the salary non-exempt classification more often?
Transitionary roles like the manager. You know, managers are difficult. It's going to be very, very fact dependent. My experience with employers is that if they can use the exemption, they prefer to use the exemption because it's easier to pay flat salaries and not have to be clocking hard overtime. And as an employer, it's a good deal for the employer. You know, you like to be able to pay the flat fee and say, I just need work being done. Sometimes it'll be, you know, over 40 hours in a week, sometimes less. To say that it's sort of more often than not, it's difficult to say. I just bring up the managers because the executive exemption is very popular for that reason. To say, oh, this is a managerial role, they're making $684 a week, so they meet all of the requirements, boom, we're going to put them in the non-exempt status. But not as often will employers actually look at what a day-to-day looks like for that employee. And it's true, the manager may spend 20 minutes a day filling out paperwork or sort of doing what we consider classically managerial roles. But if they're spending the rest of the day sitting behind that cash register, or if they're on the sales floor, or if they're doing the same type of work that the people they're managing are doing, then you're probably going to have pretty big issues with the misclassification. Not sure if that answers the question, but I hope so.
I think it answered it in my eyes. It's a good question. Do you want to get to Val's question, Melissa? There's a good one there. Oh, Megan says it answers the question, so there you have it.
Okay, thanks, Megan.
Melissa, will you read Valerie's question? You're
I was on mute. Sorry about that. Yeah, Valerie said, you mentioned that California and Massachusetts are often leading the way for labor and law changes. To your knowledge, are there any such laws in the pipeline that may have an important impact?
Given the heat waves this year on, I think, both of the coasts, I would anticipate that there will be changes to the recovery or cool down periods. There may be additional changes to, what you need to provide to, especially employees who are outdoors and spending a lot of time outdoors, as far as, making sure that they have water, that they have shade. So those are definitely out there. And I think that's something that, the unions and labor professionals are really looking at and are very concerned about enforcing for their, for the people they represent and for the larger industry and for workers. Minimum wage is always a hot button issue, and that's something that is, constantly being looked at and evaluated. So you always want to double check your minimum wage laws every year, because there could be changes to those as adjustments are made for cost of living, especially in states like Massachusetts and California that tend to be a little bit more progressive with where they peg their minimum wage. Anything, Charlie, that you can think of?
Yeah, these are sort of tangentially related. There are three big changes in California that I can think of. One of them may have already happened. The first is that California changed its independent contractor test to the ABC test, is what they call it. It made it harder to be classified as an independent contractor and more likely that you'll be found to be an employee. And as an employer, as you can probably guess, it's pretty important to know whether you've got an employee or an independent contractor based on, paying workers' comp, being able to pay for insurance reasons, things like that. So if you're an employer, maybe something to have on the radar. If you haven't checked whether or not this person's an independent contractor, it may be time to give another look to that. Second one, I believe that California is changing its arbitration laws. So it's pretty common for employee handbooks or severance agreements, things like that, to have clauses saying if you have a dispute with this employer, you have to handle that in arbitration. And employers like doing that because it's cheaper, doesn't have as extensive discovery. You can sometimes you can even keep those out of class actions. You can have single person arbitrations, but the state of California has tried to really limit employers' ability to push these disputes into arbitration. And so you now have to, I think, get maybe extra levels of signatures or agreements from an employee before you can have an arbitration provision in your handbooks. And then the last one, I'm not sure if this is a change yet. This is something that's kind of on the federal level that I've heard murmurings in California too, is that non-compete provisions are sort of not popular right now, that the Biden administration is trying to do away with non-compete provisions. And I think California also is trying to prevent their application. So if you are thinking about having severance agreements or about signing non-competition agreements with your sort of high-level executives at the time of their joining up with the company, you might want to give a local look and soon maybe even a federal look before you sign some of those agreements, because they might not be as effective.
Yes, that's such a good point. And I think that really has been something that the Biden administration has latched onto, and their use in, especially, they're pretty common in industries that really are heavy with their intellectual property, or with, software designers or employees that really do have a lot of specific knowledge about proprietary information. And I think in those areas, they're still probably going to be okay. But what has started to happen, and not necessarily in the cannabis industry, but just more broadly, I think for all employers, start to look at this and say, oh, wow, isn't this a great way to protect, essentially our share of the market by preventing valuable employees on any level from leaving? And so I think that there is a concern, and rightly so for some employees, that it's being abused. And so I think that we really will see a lot of changes to those types of laws and laws prohibiting that.
Right.
Melissa, you're muted.
Thank you. Sorry about that. We have a couple more questions here. Someone wrote, I know of companies that do not pay overtime because they are a cannabis farm. They believe that they fall under agricultural work in Oregon. Should cannabis farms be considered to fall under agricultural?
Oh, I can speak to this a little bit. The federal statute language in the FLSA is pretty broad. I think it's something like farming. I'm not, this is not my legal advice. This is sort of my intellectual opinion. I'm just, I guess, spitballing here. I would think that cannabis would fall under farming. If you're pulling something up out of the ground, that's probably farming. But that's not the only box you need to check if you're trying to meet the agricultural exemption. You can only have had 500 man hours in farming in the last quarter. If you break that out to 40 hours a person, that's about 8 people. So if you have 9 people working, they're 9 to 5 farming, then you've exceeded the man hours for that quarter, and you're probably not going to be able to meet that exemption. The exemption also, I think, applies for sort of family members or minors, people under 16. It really is sort of a smaller exemption. It's not for these sort of big scale farms if you have lots of employees. I think that it's designed for, if you have a family operation, or, if maybe one season out of the year you have a couple people farming. If you're commercially farming cannabis and you have quite a few employees, I would give a pretty hard look to the agricultural exemption, because there may be a decent chance that you don't meet it. Got a comment here. In California, cannabis is under wage order 4, not agricultural pay. That may be. It may be that California, considers differently. I would say that I think for the federal statute, I think it might be broader than the wage orders. So that might be good evidence that it's not farming. If you can say, oh, well, we had this whole string of wage orders in California that sort of box the different professions, and California doesn't consider it within the other agricultural. But it's a pretty big word, it seems, federally, and I would think that, at least if I were litigating it, that would be my attempt. If I were the plaintiff, I would want to push it as the, if I were representing a company, I would try and push it into that exemption. I think that there's space for it.
And again, I think that is, that question right there highlights why this can be fairly tricky, because there are federal and state laws. And so, when you have a question, especially like that, and especially when it seems like things are, maybe in conflict, it is always a good idea to, invest in the money to consult someone who is an expert in that area. The question about the Ninth Circuit decision as of 9/15/21. So that was a circuit court decision. We are anticipating that will be appealed to the Supreme Court. And so for right now, the Ninth Circuit did, lift that injunction, but I would continue to keep an eye on that, because I would think it will go to the Supreme Court.
My understanding of the law is that it's not a total bar on arbitration provisions. It's that it has to be in some way more voluntary. I think I've been advising clients to put the language in black and bold underline, and then maybe separate it out from an employment agreement and talk it through with an employee, rather than just sort of having it in a packet you might give for an onboarding session, to really sit down and say, this is what you're signing. You need to know this is voluntary. But I think there's still space for them to exist. Yeah, they can't insist. I think that's right. Yeah.
Yeah, and I think there were, I mean, the Ninth Circuit really did kind of focus on the sections that allowed for criminal penalties against employers who mandated the agreement. So I think that there, like Charlie said, there is a lot of room here. That's a great question. I mean, frankly, that could be a whole other article and a whole other, you know, brown bag lunch kind of series here. There is really a lot going on with AB 51.
All right. Oh, is the Q&A separate? Does this have?
Yeah, there's kind of, they're kind of ping-ponging here back and forth. So yeah, the Q&A section has a couple left. So Jamie Leo asked, along the lines of Valerie's question, a question about the old chestnut of regional salary differences. In the regions and cities that pay significantly lower salaries, are there dynamics at play that may impact better employment options for industry workers there as the industry matures?
Sorry, Melissa, could you repeat the question?
Yeah, of course. In the regions and cities that pay significantly lower salaries, are there dynamics at play that may impact better employment options for industry workers there as the industry matures?
Specifically the cannabis industry as it matures, you know, are there opportunities for wage increases in rural areas, you know, that maybe don't have as much of an economy traditionally?
Right. I mean, I do think a lot of that. So if you are in a state that has a higher minimum wage requirement, then that could potentially be something. But, you know, a lot of that may be market driven. And if you are willing to pay, I mean, like with anything, if you're willing to pay your workers more, then you may see a lot of attrition. Charlie, you look like you were just about to say something.
No, I agree. I think that's right. Yeah.
Yeah, that seems to be more of a market question. And speaking on that, you know, given our role in building a marketplace for the cannabis industry, I can say that, you know, market dynamics are definitely at play here. And we've actually seen in the cannabis industry, for I think two reasons. One, in certain areas, it tends to actually pay a little bit higher than a comparable retail worker job because the basket size at a dispensary, for an example, is significantly higher if you're ringing up 100 orders a day at a dispensary versus 100 orders a day at a deli or a convenience store. You know, you're going to have a lot higher volume, and therefore the business can afford to pay the worker more. And in fact, there's a lot of areas, I know in Michigan, this has been actually covered in the Detroit Free Press, where restaurants, hospitality has sort of said, hey, you know, we're kind of losing a lot of workers to the cannabis industry because, you know, people want to work in it. It's kind of a cool industry that people are passionate about, and they're paying a little bit more competitively, and they've had to compete with that. So I think as the industry proliferates, you'll see that across the country in both rural and urban areas, which ultimately is a good thing because it market economy creates opportunity, and hopefully with this industry gives people a path to a middle class wage.
Yeah, and Sloan, that's a great point, and that kind of goes back to the exciting position that you all are in to take care of, you know, your employees, to build up this industry, to make it be what you want it to be. So it is a very exciting time for everyone.
Yeah, and Naomi mentions a great point, which is the basket price is higher. However, cost of doing business is higher. Specifically, as we know, 280E, which is a federal tax element that this industry doesn't get, and just generally taxes and compliance can be quite expensive. That's, I think, a whole other bucket of shrimp, as I like to say.
Yeah, definitely. I don't know about Charlie, but I am not. We should have another disclaimer here about taxes and tax law, especially in this industry. That is not. I am not qualified to speak on that whatsoever.
It looks like there's one more question here, and then we're gonna wrap
two
up.
more.
Two more. Valerie asks, are there any specific legal issues around hiring delivery drivers in the cannabis industry? That's a great question. Anything related to drivers, whether it's in California or elsewhere?
I mean, the interstate issue is very thorny, and and interstate issues with transporting any type of cannabis, regardless of the THC levels, that is definitely something that is very difficult and is something to consider when you're hiring delivery drivers. If you're thinking you're going to go across state lines, even with a product that has tested as hemp, you really just, paperwork is your friend. Make sure everything is well documented for any delivery driver. Of course, there are safety issues. I've represented clients where there were, issues with break-ins and theft. So there are safety issues for drivers as well. I don't know, Charlie, can you think of anything else?
Yeah, I can think of sort of two big issues that are going to have with delivery drivers. The first is that if they're driving commercial vehicles and if you're engaged in interstate commerce, then there's a very good chance you're going to actually be regulated by the Department of Transportation and not the Department of Labor. Sort of bizarrely, I just finished a suit with a landscaping company that was on the border of Kansas and Missouri and was driving commercial vehicles back and forth. And they became a DOT company rather than DOL. And if you are under the DOT, you are accepted from FLSA because you're not regulated by the Department of Labor. You're regulated by the Department of Transportation. So if you have delivery drivers and they're driving big trucks that are over 10,000 GVR, then you may not have to pay overtime. That's something to think of, but it also means you have a whole slew of regulations from the Department of Transportation that you're probably going to have to meet. And my guess is that they have far more stringent cannabis sort of regulations than the Department of Labor would have. The second that I would think of
would that apply to even a retail, someone driving just to, because in California, as an example, there's a limit to how much you can have in the car. So these aren't technically commercial vehicles; they're usually personal vehicles. Or
commercial vehicle,
they're the size of a personal vehicle.
Exact. So your commercial vehicle is defined by its gross vehicle weight rating. So it's sort of a weight like load limit on the car. So if you are driving just like a Ford F-150 pickup, you got a trailer attached to it, and the trailer has its own weighting of 5,000 and the car has a weighting of 7,000. You add them up, that's going to be over 10,000. And if you're driving that over state lines as part of the business, then you're probably DOT regulated. You should probably have a DOT number, and you should probably look out for roadside stops.
No one's driving across state lines legally in the cannabis industry.
Oh, okay. Well, then,
yeah.
Then if you're not doing interstate travel, then you're going to be okay on the DOT front.
And you would not have to pay OT.
If you are not regulated by the Department of Transportation, then you probably will be by the Department of Labor. That's sort of the breakdown. DOL is FLSA sort of column that is overtime requirements. Department of Transportation, not FLSA, no overtime requirements.
Got it.
Yeah.
That's it for our questions. Unless there's anything else, it looks like we got to everything. And I believe that we're right at time at 4:40, so we're right on time. I want to thank Charlie and Stephanie for joining us here today and for talking through this. I mean, this is an incredibly important topic. There's a lot of folks, there was over 35 people on the call, and we'll send a follow-up, but is there a way that folks can reach you? Should they have follow-up questions or want to dive deeper and get into official legal advice? How can they reach you folks?
Sure. So you can find us on our email on our website for our company. Charlie, can you go back to, do you have our contact information on our bio page?
Oh gosh, hopefully, perhaps not.
Here, we can plug in, we can shoot it in the chat.
Yeah, I'll put it in.
We can put it in the chat.
Yeah, put it in the chat real quick, that way people have it. And then what's cool is, Melissa, I don't know if you saw, but Naomi, who I met out here in the Hamptons, Naomi Granger, is down to talk about tax in another careers in
Awesome.
cannabis. She's an accountant
That would be
and knows the
great.
industry cold. So you show up to one of these, you may get recruited to speak on the next panel. So watch out. And we are going to be doing these much more regularly. We had a little hiatus as we were really reorganizing our content, and Melissa has a great slate of upcoming events, and we would encourage anyone in the community to reach out and just respond right to the weekly emails that Melissa sends out. If you have any specific things you want to hear about, specific questions as it relates to running your cannabis HR team, that's what we're here for. We're here to support you and the cannabis human resource community. Melissa, anything you'd want to say before we wrap up?
Yeah, and if you are not on the weekly email list, you can, and want to be, you can email me at melissa@careersincannabis.com, so I can add you to that. And obviously, if you are someone who wants to host one of these, please let me know. And I will be sending out a recap and a recording of today's event as well in the next coming days. So thank you so much for joining.
Thank you, and thank you, Stephanie. Thank you, Charlie. I personally learned a lot, mostly that we should probably move our headquarters out of California. Sounds like it's a tough place to operate. But it's the beach, you know, got to take the good at the bad.
Yeah.
I can use this.
All right, everyone. Thank you so much. Have a wonderful day.
Thank you, Stephanie.
You too.
Thank you, Charlie.
See
Thanks,
ya.
everyone.
Bye.
Oh, hello, Stephanie.